In the witness statement of the defendant's legal representative, Laurie Swain, he asserted that the defendant denies all liability. The image is not of the claimant, and the image complained of was involved in an unsolved crime at Tiffany & Co. on the 24th of December 2012. He submitted that my claim should be struck out for abuse of process. The above statement from Laurie Swain seems authoritarian to me. It suggests that to stand up for your rights in court is to abuse the process of the court. On the 13th of May 2016, I received the schedule of their costs, £1,916.70, plus their counsel's costs, to be added. On the 17th of May 2016, we had the hearing, but this was stayed for amendment. My human rights claim was struck out because it was time-barred. The two misfeasance in public office allowed to continue, along with the misuse of private information, with amendment from both sides. Back to the allocation questionnaire stage. On the 18th of August 2016, I received a notice of proposal for allocation to the small claims tract from the court. On the 2nd of September 2016, I filed a second application notice to strike out the defendant's defense on the grounds that 1. On the 5th and 13th of May 2016, the respondent filed documents and exhibits in the court and served the same said documents and exhibits to the applicant, when he knew or ought to have known that the said documents and exhibits were false and or falsified. 2. The applicant contends that the respondent's employee and or agent falsified the relevant documents and exhibits pertaining to the proceedings. 3. Documents and exhibits which falls into the category of tainted evidence. A. Laurie Swain's witness statement, 5th of May 2016, and supplementary witness statement, 13th of May 2016, and all exhibits LS1, LS2, LS3, and BA-1. Any and all evidence relating to suspect 3 and all reference to image number 113699 in connection with a crime. Step 12 in the Metropolitan Police Dirty Tactics. Get a false witness statement from an ex-police officer to tip the balance back to the defense and attempt to get the application notice dismissed. Within 3 days of my application, on the 5th of September 2016, the Metropolitan Police requested and or received a witness statement from Ellen McKay, the European Director of Security for Tiffany & Co., who contended that she's 100% certain that image 113699 is the same person in the CCTV footage as in the most wanted poster. The witness statement from Ellen McKay is a blatant lie, and she knew or ought to have known that her statement was untrue and or a total misrepresentation of the facts. The person acting as suspect 3 in the alleged CCTV footage is different from image number 113699. The only similarity between the two images is they're both black men. In a letter dated 1st of September 2016 from Clyde & Co., they made reference to a letter that they had sent to the court manager at the county court at Central London. They contended that they have received a copy of my application notice dated 2nd of September 2016, and that it is identical to my application dated 22nd of February 2016. They submitted that my application dated 2nd of September 2016 be dismissed. They requested that all 3 applications should be heard together at the same time. They further requested that their letters should be referred to the judge before the listing of the hearing. Documents included with this letter sent to me on the 1st of September 2016. 1. Third witness statement from the defendant's legal representative, Laurie Swain. 2. Witness statement of Ellen McKay. 3. Photocopies of the manipulated images of 113699. 4. Photocopy of the recent picture of myself that I sent to them. 5. Copies of my particulars of claim and amended particulars of claim. 6. Copies of my reply to the defense. 7. Copies of their defense and amended defense. 8. Exhibit MH1, which is a photograph of the entrance of Tiffany & Co. with the doorman opening the doors, with nobody actually entering the store at the time. 9. Interestingly, no CD this time around. In a letter on the 12th of September 2016 to the court manager, I requested that my application notice dated 2nd of September 2016 be heard separately, or in the alternative that the 3 hearings are listed together, that the application notice dated 2nd of September 2016 is heard before the 2 outstanding hearings. In the same correspondence, I filed an objection to the inclusion of Ellen McKay's witness statements on the grounds that the opinion and statement of Ellen McKay in her witness statement is prejudicial to the proceedings by the fact that A. She was not directly involved in the investigation. Her only input was to approve the release of the CCTV footage to the police. B. She admits that the original source footage had been destroyed some time ago. C. She asserted facts she would have no direct knowledge of, and in her statement she repeats the defendant's defense. D. I alleged that she had been primed by the defendant by first showing her the CCTV footage, which I regarded as tainted evidence, then showing her the Met Most Wanted poster. In a letter on the 7th of September 2016 to the defendant's solicitor Clyde & Co., I requested a copy of Exhibit MH1. This image was only sent to the court for the judge's attention, but was never sent to myself. On the 14th of September 2016, I received a copy of Exhibit MH1. On the 6th of October 2016, I received from the court the hearing date of the 9th of January 2017, but no judge's order and no court seal on the documents. The hearing was scheduled for 2 hours. Without the judge's order, it was unsure whether the hearing was for 1 or 3 hearings being heard together, but I just presumed that the hearing date 9th of January 2017 was for 1 application. In a letter on the 20th of October 2016 from Clyde & Co., Laura Swain asserted that he had spoken to court staff and they have agreed to hold the 3 interim hearings together on the 9th of January 2017. In a letter on the 25th of October 2016 to the court manager, I complained that it appears that the defendant and or his legal representative had a private audience with the court staff, to which I'm not privy to the details of the conversation. I further contended that no rules under the CPR or PD allow the court staff to override a judge's decision, and no judge on the same level can override another judge's decision. Further, in a letter 25th October 2016, I complained to Clyde & Co. I asserted that I wanted to know what method of communication was used to communicate with the court staff, and what was said. They failed to reply and or to address my complaint. On the 8th of November 2016, I received a letter from the court, a Mr. John. He contended that we acknowledge receipt of your letter dated 13 October 2016. And write to inform you that it has been referred with the court file to the district judge for consideration. But I had not written a letter to the court on the 13th of October 2016. Did not have a clue what he was talking about. On the 23rd November 2016, I received a judgment order from District Judge Price. It contended that upon considering the defendant's letter dated 13 October 2016, it is ordered that the two applications of 22nd February 2016 from the claimant and the application of 5th of May 2016 from the defendant be listed at the hearing on the 9th of January 2017 at 2 p.m. with time estimate of 2 hours in total, dated 11 November 2016. On the 25th November 2016, I sent an email to the court manager contended that I note with respect that the court has found a way to circumvent the claimant's objections to all three hearings being heard together. I admire the clinical and legal way it was done by placing the two state hearings of the 22nd of February and the 5th of May 2016 at the same time and date as the application dated 2nd of September 2016. All three hearings dated 9th of January 2017 at 2 p.m. I respectfully request that the court hear the application dated 2nd of September 2016 before the two state hearings dated 22nd February and the 5th of May 2016. Otherwise, the court might be seen to be showing bias in favor of the defendant. I will appreciate a response to confirm this request. No response was received from the court manager in regards to this request. On the 29th of November 2016, I sent a recorded delivery letter addressed to the court manager at the Royal Courts of Justice, County Court, Central London, at the Thomas More Building. I requested clarification in regards to the application dated 2nd of September 2016, whether or not it will be heard on the 9th of January 2017. The judge's order on the 23rd of November 2016 made no mention of the application dated 2nd of September 2016. No response was received from the court manager in regards to this request. On the 5th of December 2016, I made an official complaint on Form EX343A because it appeared to me this was the only way I was going to get a response from the court manager. He or she is compelled to respond to the contents of the complaint. They are not compelled to reply to letters or emails. On the 15th of December 2016, I received a letter which addresses my formal complaint. This letter was from the team leader, a Mr. Robert, who contended that, in your complaint you note that the court failed to enclose an order with the notice of the hearing. I've consulted the court file and the judge did not make an order. The judge just gave direction to list the application for hearing. The judge's direction, hearing notice, and applications are on the court file for the hearing listed 9th of January 2017. On the 20th of December 2016, I filed with the court my first witness statement. On the same date, I sent a copy of the bunker evidence with my witness statement to the defendant's legal representative, Clyde & Co. On the 2nd of January 2017, I filed a supplemental witness statement with the court. On the same date, I sent a copy of my supplemental witness statement with copies of snapshots taken from the alleged CCTV footage at Tiffany & Co. to the defendant's legal representative, Clyde & Co. The snapshots contains the three alleged suspects and the alleged sales professional from Tiffany & Co. It can be seen clearly that the alleged suspect 3 looks nothing like 113699, other than he's a black man with a short haircut and no receding hairline, aged no more than 35 years old in my opinion.